All right, we're live.
Hi everyone, thanks for joining our stream today. I'm going to be going over some general trends with USCIS, and we will talk about how those are applicable for EB2 and IW cases and EB1A cases, but I also want to step back and do this a little bit more broadly, where we're talking about what's happening with USCIS for you personally, if you are either in that process or thinking about going through either one of those processes. There's a few different trends. I have my sticky note up here to make sure that I talk about all of them. One trend that's been pretty prominent, at least on the US government's social media pages, in some of the news outlets, in a lot of the statements that the agency has been putting out, in press releases, and so on and so forth, has been this emphasis on turning USCIS into more of an enforcement agency and less of a service or administrative processing agency. USCIS in the last Trump administration actually changed their whole mission statement and their goal to be more aligned with an enforcement agency. And we are definitely seeing a resurgence of that as well here. So practically, it should be fine, like as long as you are not engaged in anything strange or don't have a criminal record or don't have prior immigration violations. Most of the time, it's fine. Where this can get a little bit dangerous, though, is when officers are assigned to do the enforcement and they don't know how USCIS processes normally work, and they're encountering a situation that they're not familiar with or not trained in. I've seen this a lot, for example, where officers who were used to adjudicating big corporate L1 visa petitions would then adjudicate really tiny international or multinational company L1 petitions. They had some very strange ideas, and they actually tagged some of these small companies with fraud or misuse of the L1 program, even though every single legal definition was complied with, just because it was strange and it wasn't what they were used to. I've seen a situation come up this week, actually. We did a consultation, Alex and I, with someone who filed their NIW petition, and it's not a strong NIW petition, so we would expect the NIW to be denied. But they actually flagged issues with the prior employer's I-140 petition, and they didn't mention fraud or misrepresentation, but they're certainly making those kinds of allegations on the record. And it's very distressing because this is clearly stemming from an officer who doesn't routinely handle employer petitioners, so perm-based I-140s, and thinks that there's something wrong when there's not. Like the petition is just proceeding normally how all I-140 petitions proceed. So a lot of times the emphasis on enforcement can cause issues for high-skilled immigrants when the officer who's looking at the case is seeing something that they don't understand, and because they don't understand it, they are accusing the individual immigrant of something. If this is you, so if any of these issues come up in your EB2 and IW adjudications or EB1A adjudications, you definitely need to clear up the record. Like, don't just let those kinds of allegations or insinuations stand on the record. So in the case that we're advising on right now, we are advising that they withdraw the case. It's not a strong NIW. There's really not a good argument that it should proceed forward. But even though we're withdrawing it, we're not just withdrawing it. We're going to withdraw it and explain why there is nothing wrong with the past record. Otherwise, I'm concerned that they will actually flag this person's file for misrepresentation and try to get them kicked out of the country, even though nothing is wrong. So just be aware, protect yourself. If anything comes through in an RFE or an official notice that you think is accusatory, you should probably treat it as accusatory and you should respond accordingly. You should clear up the record. You should make sure nothing is standing on the record that is unclear or ambiguous or insinuates that you've done something wrong. Another small trend, I'll say it's a small trend just because I've only heard of a few limited cases, it's not widespread or anything like that, is revocation of approved petitions. We saw this during the last Trump administration. We're starting to see it again during this Trump administration, where some USCIS officers are empowered to issue a notice of intent to revoke on an approved immigrant petition, like an EB2 NIW or an EB1A. A lot of times the notices of intent to revoke don't actually allege any kind of mistake or error or anything in the original adjudication, but they're essentially saying that the person doesn't actually meet the requirements. This is a little bit scary because given the state of EB2 and IW adjudications right now, reasonable officers differ on what qualifies for NIW and what doesn't qualify. So if USCIS is not required to state an error, any case is up for revocation. Literally any case. I don't think anyone is safe. Any reasonable officer could come up with a reason to say that someone is not qualified. And I don't say that to scare anyone. Again, this is a very small number of cases that are impacted right now. But if you do get a notice of intent to revoke, treat it seriously, make sure that you get legal counsel, and make sure you respond to it right away. You may need to actually take cases like that to court, or go to the AAO and ask for an appeal on those kinds of situations. All right, so that covers a lot. There are a lot of people, especially in EB2 and IW adjudications right now, who are being impacted by this F1 student visa revocation issue. I've worked with a couple clients who were ready to file their EB2 and IWs, but their visas just got canceled and revoked, and their CIVIS records got terminated. So now they're in this state of flux where they don't know if they hold legal status, they don't know when they're going to be required to leave the US, they don't know if they're going to be put in deportation proceedings, and there's a lot of uncertainty there as well. I will say, according to the government's court filings, the government doesn't even know if they have status, or if they're going to be issued NTAs for the deportation proceedings, or if they're going to be kicked out of the country or allowed to stay and finish their program. No one really knows what's happening here, and it's very, very frustrating. If this is you, make sure that you have some kind of community with other people who are in the same situation. So other people who are here on F1 status, who have had their visas canceled or revoked, make sure that you network with them, that you can share stories with them, that you can share resources, attorneys, information, and guides. There's a lot of really good information out there, like all of the attorneys have started sharing. And so if you can network with other students in your situation, you are more likely to get good information. Also, definitely consider suing the government on this. Just like with some of the revocations, you can sue the government. Just like with some of the misrepresentation or fraud findings, you can sue the government if they're not being fair about it. And then for this as well, if your status is revoked or terminated, you can sue the government. It's going to be a theme. Sue the government. That's what happened during the last Trump administration, and it's definitely happening even more now. They're doing all kinds of things that are not in accord with sound principles of administrative law. And so a lot of what they're doing is illegal. And I'll just say, they accuse immigrants of breaking the law when they are the ones breaking the law. All right, that's an aside. As far as international travel is concerned, it's another big thing that I've seen come up. Usually in all of my EB2 and IW and EB1A consultations, I'm going to be asking about whether or not you have international travel plans coming up, so that when we're preparing the case, we know what to expect. There's another layer here right now where if you are planning international travel, you have any kind of criminal infraction on your record, even if it's just like a case of mistaken identity where you were fingerprinted at the police station, even if it's a really minor misdemeanor that you just had to pay a fine for, any kind of negative encounter with law enforcement in your past or in your record, I would say do not travel internationally right now. The CBP is using some new system to put flags in people's records, even for things where they've been totally cleared of any wrongdoing. So it's just very risky to travel. I would not travel. If you are politically inclined and you are discussing politics on social media, especially any politics that could be critical of Israel, critical of Trump, potentially critical of tariffs, hopefully not. I haven't seen that yet. But I would say any political activity on social media, just be very careful. And if any of that political activity relates to Israel-Palestine, don't travel. Just don't do it. It's not worth it. because they are screening for that kind of thing now, and that can lead to you getting banned from the US. As well, if you are traveling to or from, or if you have a passport from any country where the US has a particularly bad relations right now, especially those countries that have been on that pre-published travel ban list. There's no travel ban yet, but there is a list floating around. I would say don't travel, because you will definitely be subject to additional scrutiny when you re-enter the US. And that includes legal permanent residents. Like I have worked now with a couple legal permanent residents from Iran, I think one from Sudan, and I'm just recommending that they don't travel at all. We've seen legal permanent residents be held. We've seen now legal permanent residents being put into proceedings to strip them of their status. It is not worth being in that situation right now, to take a trip, even to see family, even for important events. So being a legal permanent resident does give you more rights, but the government right now is trying to push back against those rights to the maximum possible extent. And I would not recommend putting yourself in that situation. Overall, we talked about how USCIS is now more of an enforcement agency. We talked about trends with revocation, trends with student visas being revoked, trends with investigations at the agency, and then trends with travel. If you want to go ahead and post questions, please feel free to post questions. I'm happy to answer. There can be other questions too, just about NIW trends, EB1A trends. I'm happy to answer anything like that. But let me know what your questions are. Jason, have you seen anything come up, questions that we should address or answer in line with the trends for high-skilled immigrants?
So in regards to travel, not really, but generally speaking, for both for NIW and EB1A, a lot of people are starting to ask their employers to guide them through the process. Is that something you would suggest people do, to ask their employer to help them with EB1A and NIW, given that there are more self-petition options?
I definitely do not. The main benefit of having your employer involved is that they will pay for the process. So I don't want to diminish that. It can be a significant cost. And if you really need your employer to pay for it, that's fine. You can ask them to do the whole process for you and guide you through the process. But keep in mind that if your employer controls the process, they are the petitioner. And one of the main benefits that most high-skilled immigrants are seeking is independence from their employer. Filing with the employer does not give you that independence. Only filing on your own will give you that independence. So look at filing on your own if you can. The only benefit, again, for filing with the employer is that they might cover the cost. That's it.
A couple of questions are coming up. Lost H-1B job on March 21st, 2025. Employer revoked visa on April 8th.
Yeah, so this is very normal. The employer is supposed to send a notice to USCIS when you are no longer employed in the job. So this is very, very normal. You may have to calculate your grace period from March 21st, but you should look at your pay stubs and see what your last paid work day was. Sometimes it will be through March 31st. And you may be able to calculate your 6-day grace period based on that. Alexandra Law and I are doing a bunch of layoffs consultations. So if you want to talk to us and get some resources for potentially filing a B2, feel free to reach out to Alex as first point of contact. I think that would be good.
Caesar asks, I've seen several posts about cases very well prepared by attorneys for EB2 and NIW being rejected. What is the best way to prepare a case with everything going on?
Yeah, just before the call, I was talking to Jason about this, because this week we got 3 NIW approvals and 1 NIW denial. And I will say the denied case was the strongest of the bunch, by far. By miles, it was the stronger case. One of the cases that got approved was super, super weak. The others were like mid-level. But I'm really upset that the one that got denied is the strongest. There's an element of erratic decision making at the agency right now. I would say if you can get USCIS to read the petition, the most important things to emphasize are your impact beyond your particular job. So impact to the field as a whole. And you need to describe to USCIS why the perm process is not going to work for you, and why you need the NIW. If you establish these two things and the officer reads and fairly considers your case, you should be good. That, and of course, following the whole DNSR framework and presenting the argument in that format. But I've definitely seen cases where I'm reading the denial decision and I'm thinking, you know what, USCIS didn't even read it. They didn't want to consider it, and it's very frustrating. So I don't have tips for like ensuring that they do that. It's tough right now.
What are the trends about EB1A as regards RFEs for authorships? I'm reading a number of professionals are getting RFE for authorship category.
So I've been working in EB1As for a long time, and RFEs on authorship do routinely come up. There was some litigation, and I forget exactly how many years ago it was. There was some litigation that was super helpful in getting USCIS to apply a plain language standard to the authorship criterion and actually check it off of their list and move the adjudication on to final merits after that point. So authorship RFEs did improve after that court case. I haven't seen a huge resurgence in those type of RFEs, but I've seen a couple here or there, and they seem to be pretty much in line with what I had seen earlier in my career, where they're asking, number one, is this really a scholarly article? Is it written for people who are at the top of the field? Is it advancing knowledge in the industry? Those kinds of questions. The second thing that they will often question is the value of the publications, like how widely read are they? Are they influential or impactful in the industry? That kind of thing. And then the third thing they'll question is volume, which they're not supposed to, because under the plain language standard, 1 or 2 articles should suffice. But sometimes they question the volume and they say it's not in line with extraordinary ability. Again, I haven't seen this as a huge trend yet. I do know, though, like just based on the profile building talk that's out there, that a lot of people are claiming authorship for cases where I typically would not claim authorship at all, where like the person doesn't routinely publish, and they only did the publications while doing some profile building. So I think more people are claiming this criteria now than potentially they did in the past. And that could influence the trends as well on RFEs. I'm not 100% sure. I'll just reiterate too, like you don't need to claim authorship to get an EB1A approved. You really don't. Maybe the slight majority of my cases have authorship, but certainly not all of them. There's a very good chunk that do not include authorship.
I'm planning to apply for F1 if I didn't receive H1 transfer opportunity, if F1 isn't in the process, and if I get an offer, let's see, 120 days after laid off, can I transfer to H1 back?
So I think the question is asking, can you transfer back to H1B after filing the change of status for F1? And the answer is yes, as long as you have time left on your 6-year maximum. Your new H1B sponsor can file the H1B petition, and then once that petition is approved, you can resume working on H1B status.
I am building a profile for EB2NIW. I will be graduating with a master's in December. I should have had 5 main authors published, who of which is a novel technology to the USA and safe states millions.
So I think you're probably asking if this is a strong profile. And I think it has potential. Like, this isn't enough information for me to really tell if it is strong, or if it is strong, how strong it is. But it has potential. So if you want to submit a free assessment, I'd be happy to look at it.
clean background, EB1A green card holder, no traffic ticket, no social media posts about political. Can I travel in July to Germany for a conference? I am a doctor and scientist.
So I really can't just greenlight people's travel. That's not really my role. And you can't ever have 100% assurance on whether or not you can travel either. You didn't mention what country you're from. That could be an issue, but if you are from a country that has relatively friendly relations with the US, this kind of travel isn't high risk. It does come with some risk. All travel comes with some risk, but it's not high risk. And this isn't usually the kind of trip that I would say to cancel. It just depends, though, on what you want to do.
I also have awards and media recognition. How do you think I'll do? You recommend I wait and get my PhD first? For the
was this a continuation of the?
Yeah. Of the one about the master.
Yeah, same answer. I would need to assess what everything looks like. Again, it has potential, but I'm not 100% sure.
Already addressed this as well. If I own a company, can I sponsor my family member for perm on EB3?
Potentially, but any kind of family sponsorship receives huge scrutiny, like very significant scrutiny. You have to prove that it was a bona fide job offer that was actually open to US citizens and that you did the recruitment process properly. You will almost certainly get an audit on the perm, and you will really have to justify why your family member needs to fill that role and not a US person. I don't necessarily recommend it right now, but it is something that you can do if you need to.
Is authorship valid if the only published research has been with your university and are only in Google Scholar?
I think this is asking if it was just published on the university website. I don't know why it's in Google Scholar. Usually Google Scholar is pulling from like professional publications. I don't think most universities are indexed in Google Scholar. So I'm not 100% sure. In the NIW context, you don't need to publish research in journals. Pretty much any publication can work, but you will want to show the impact of the publication and how it's being used, why it's influential, and so on and so forth.
From the other question, yes, NIW is approved, but H1 is revoked.
It just says LinkedIn user for me, so I can't tell what comments this is related to.
It's related to the one about the F1 transfer, I think. Yeah.
Okay, it's not like H1 is revoked. That revoked means a very specific thing. Your H1B was just withdrawn because you were laid off by the company. You can still get a new H1B sponsor. That's fine.
Then just two more questions. Part asks, what if I'm actively building my profile and I have a lot of evidence, better profile in the next 6 months and I file for EB1A? Is that okay?
I'm not entirely sure what the question is asking. So just let me know if you have something more specific.
Haja asks, what is best path for someone who is on H4, I-485 EAD AP who is graduating college without F1?
I'm also not 100% sure what this is asking because you have the H4 and you have the I-485 already, so you shouldn't need anything else. I'm not sure.
Third ask again, NIW is approved. If F1 is in process, not approved yet.
Okay. Yeah, we do need to end the stream really soon. Basically, you can transfer back to H1B. But if you want more specific advice on this, book the consultation with Alexandra. But yes, you can go back to H1B.
And regarding Google Scholar, you can point your research to an article even if it's not in a journal.
Okay, I don't love that. I know that people have a way to add their own articles and stuff. I don't know if Google Scholar actively maintains that, or if you can just do it for a time, or if there's a check on it. But I'm not sure. Yeah.
Right.
Thank you everyone for joining the stream. I will have to go. But we will talk next week about more issues with EB2 NIW and EBY.
Thanks, everyone.